Hello, good evening everybody. Am I audible? Everybody can hear me? Okay, what about others? Can you hear me? Everyone? Mohammed Tariq, Akshita, Praveen, Prasoob, Sanubar, Seher, you all can hear me? Prasoob, good evening. Welcome to class. Is this your first session? Alright, so let's start with the topic for the day. Before that, I would just like to revise with you what we did in the previous class of business law. We discussed about the basics of a contract, and we basically discussed the various principles which govern a contract. Without the fulfillment of these principles, an agreement cannot be termed as a contract as per the contract law. So can you tell me some of those principles which we discussed, the principles of insurance? Can you just tell it to me? Some of the principles of insurance. The first one was, okay, Surajit is typing something, so I'm just waiting for that. Principle of indemnity, principle of subrogation, principle of immediate cause, and what else? Principle of utmost good faith, isn't it? The principle of utmost good faith says that, I'll just revise it, then we'll go to the next one. The principle of utmost good faith says that every contract must be based on mutual goodwill, means mutual trust rather. There should be a trust between both the parties who are into the contract, who have entered into the contract. Okay, there shouldn't be any fact, any material fact which should be hidden. Everything should be open and transparent between the two parties. Hello Mohammed Tariq, good evening, welcome to class. Yes Prabha, you might have been absent. I am good, thanks for asking. So that is one principle, the first one. The second I told was, okay Prabha, fine. The second I told was the principle of indemnity. Principle of indemnity says that insurance is a contract in which the party, one party, that is the insurer, it undertakes to make good your loss, or rather the contract says that the insurer will put you in the same position where you were before the happening of the event. Okay, so that is the principle of indemnity. Now there is one exception to the principle of indemnity. There is a particular class of insurance to which this principle does not apply. Can you name that? One type of insurance where principle of indemnity is not applicable. What type of contract is that? What do we call it as? Very simple. Force majeure. Rajiv, I'm talking about life insurance. Life insurance is one type of insurance contract where the principle of indemnity is not applicable, because you couldn't make anybody's loss of life, like you cannot just compensate for that. You cannot bring anybody back to life. So that is the basic idea. Alright, principle of indemnity. Then the principle of subrogation. Principle of subrogation says that, like, if you have taken insurance contract from more than one party, if there are more than, yes, it cannot be measured in terms of money, Praveen. If you have taken insurance contract with more than one party, means you have more than one insurer, so in that case, you cannot make a profit out of an insurance contract. Your good will be made good, or your loss will be made good only to the extent of the contract which you have entered. Means you are going to get like 20% of your loss from one company, 30% from your company, and 50% from one company. It is not so that you are going to get 100% from everybody. Okay, that is principle of subrogation. Then principle of indemnity, I told utmost good faith. Yeah, principle of immediate cause, that says that your loss will be made good only if your loss occurs only due to the reason for which you have been insured. Suppose one very example, one common example which I have given in previous classes also. Suppose you have kept rice in a godown, in a warehouse. Rice has been kept, and that you have taken a fire insurance policy for the same. Okay, then suddenly, all of a sudden, your goods, your rice stock gets damaged by rats. They came and they start eating it. So in that case, you are having a loss, but your loss will not be made good by the insurance company, because this pilferage or this like eating up of the rice by the rats is not covered under the insurance contract. So you won't be paid for that. Alright? Only if the loss would have occurred due to the insured reason, the fire, then only you would have got the compensation. Okay? So now we go to today's topic. This is now today we are going to discuss about the different essentials of an insurance contract. Okay, the different things which should be taken into consideration if we have to conclude a valid insurance contract. So the first thing is pre-consent. You understand the meaning of consent? Everybody? Consent means your agreement to do something. Okay, so every insurance contract must be backed up by free consent. Means the consent should be given by the insurer by his free will. Okay, he shouldn't be forced to enter into any kind of insurance contract. Suppose I put you at a gunpoint. Sorry, I won't put you. Somebody else like puts you on the gunpoint and asks you to sign the papers. So is that a case of free consent? Praveen says no. What about others? Is that free consent? When you are forced to sign a contract on the gunpoint. Prabha, the question is, if you are forced to enter into a contract, if you are asked to sign certain papers on the gunpoint, a gun has been kept on your forehead, and then you are asked to sign a contract. Is that a case of free consent? No, that is not a case of free consent. So every insurance contract must be backed up by free consent. So what is the meaning of free consent? It says there should be consent. Consent means the agreement, and then the consent must be free. It shouldn't be forced. Okay. So there is a particular term in insurance that is called as coercion. Okay. It's called coercion. We'll be studying about it in the the coming slides. So coercion means when you are forced to enter into a contract. So there shouldn't be anything like that. So Now Section 13 of the Insurance Act defines consent as two or more persons are said to consent when they agree upon same thing in the same sense. That is consensus ad idem. It is with free will. It's not forced. So insurance contract is a contract which has a free consent in it. So the consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, or mistake. If it is under the influence of either of these, it won't be taken to be free consent. So coercion, I told you, when you are like forced to do something, like what you call in Hindi is dhamki. When you are threatened to do it, that is coercion. Then undue influence, when like you are under the influence of somebody or something and you sign a contract, you enter into a contract. So if you say that I was under the influence of this thing, suppose you have been, that's a very bad example to give, but I am still giving it. Suppose you have been drunk and then you enter into a contract. Is this undue influence? Entering into a contract under the effect of alcohol, is that a valid thing? No, that's not valid. So if the contract is entered in that way, it will be void. Void means zero, null. It won't be effective. Then fraud. Fraud is what Prabha told us, that like sometimes insurance agents they give wrong information, incomplete information. So that is fraud. Then misrepresentation. It is also similar to fraud only, somewhat similar. The mistake is sometime by mistake you might enter into a wrong contract. So consent should be free. So what is coercion? In simple words, coercion means forcibly compelling a person to enter into a contract. Like X threatened to kidnap Y's son if it does not lend rupees 50,000 to Z. So Y agrees to lend the amount to Z. So though the coercion proceeds from X against Y's son, yet the agreement is entered under coercion. Okay, there is not a direct relationship between X and Z. Z is not doing anything. He is not forcing X to give the money, but X is forced by Y. So in that case, this is a case of coercion and the contract is null and void. It's not valid. So what does coercion mean? It is committing or threatening to commit any act forbidden by the Indian Penal Code, or the unlawful detaining or threatening to detain any property to the prejudice of any person whatever, with the intention of causing any person to enter into agreement. Means when you forcefully make a person enter into a contract, and that can be related to any property or it can be related to any person. So that is coercion. So can you give me any example of coercion? Anybody? Bribe. Bribe, not exactly, Rajiv. Bribe is not coercion. You are not forced to give bribe. It is by your choice that you are giving it. Okay. Kidnapping. That is a case of coercion. Yeah, yes, Prabha, that's a good question. How it is decided? It is decided, and in the court, if you say that you were under coercion, you have to prove it. Okay, only then your point will be valid. Your lawyer has to prove this point. Otherwise, it is not taken into consideration, this point. Then, when consent is caused by coercion, what are the situations in which it happens? The first is like committing or, torture, we can say. Committing or threatening to commit any act forbidden by Indian Penal Code. The example says X threatens to kill Y if the latter does not agree to sell his diamond ring for 1500. So do you think 1500 is the appropriate amount for a diamond ring? Not at all. That's not uh, appropriate. And then what it is, because threaten to kill is forbidden by IPC, that is Indian Penal Code. So that's not applicable. Now there is a case. It's Ranganyakamma versus Alvar Setti. This case says a Hindu girl of 13 years who had just lost her husband was forced to adopt a boy of their choice by her relatives, who refuses to remove the dead body of her husband unless she consented to the adoption. It was held that the adoption was not binding on her since her consent was obtained by coercion. So any person who obstructed the dead body from being removed would be guilty of an offence under section 297 of IPC. Alright? Clear? Meaning of coercion is clear to everybody? Okay. Then next is if there is unlawful detaining or threatening to detain any property, if it is so. The cases of this one, Muthua versus Muthu Karuppa. It says an agent refused to hand over the account books of business to the new agent sent in his place unless the principal released him from all liabilities, and such release had to be given before the new agent could get the books. Held that the release deed was voidable. No. Yeah. Family emotional blackmailing. That is also one aspect of coercion, one type of coercion. So in this case, this agent who was found guilty of some kind of misrepresentation in the account or fraud, he forced to leave the place unless he was declared free of all the liabilities. So this was coercion. He was forcefully getting it done. Now what are the consequences or effect of coercion? The first is the contract is voidable. Voidable is like it's cancelable at the option of the party whose consent was obtained by coercion. Then any benefit has to be restored back. If the aggrieved party does not opt to set aside the contract, it works as a valid contract. Yes, if the other party, they are not able to prove their point and they accept the whole thing, then it is a valid contract. Then does threat of to commit suicide amount to coercion? Yes, this is also coercion. That is emotional blackmailing, as Prabha said. If you say, if you will not do this for me, I'm going to commit suicide. That is emotional blackmailing. We see in Hindi movies, lots of them, isn't it? So it's better we don't indulge in such things. Now what is undue influence? The second type of point which makes the consent non-free. It says the strong mind overpowered the weak mind of a person and induces him to do which he would not have done if left to his own judgment. So it is a kind of mental coercion. The presence of undue influence at the time of contract has to be proved by the party alleging that undue influence existed. You have to prove it again. Now do you all follow that show, Big Boss? Big Boss on Colors channel. Do you follow that? Big Boss. Asya, Ashwin, Sahel, Rajiv, Akshita, Praveen, Sanubar, Rahul, Prabha, Habibur, Muhammad, Tariq. Okay. So, in that show, every time there is somebody who influences the other person. This time it is Puneet who is influencing Gautam. If you follow that show, then you might be knowing it. So, that is undue influence. Since you are good at talking, You are good at verbal skills. You are making a fool of the other person. You are influencing him or her. So that is undue influence. So the definition says the relations subsisting between the parties are such that one of the parties is in a position to dominate the will of the other. So he uses the position to obtain an unfair advantage over the other. Okay, you watch Survival of India. Survivor of India. On which channel does it come? Praveen, I don't follow that. Yes. So this is the definition, and it's normally Star Plus. All right. So he uses the position to obtain an unfair advantage, and the one party should be in a position to dominate the other party. Like suppose sometimes an employee in the office is harassed by his or her boss. So that may be undue influence. His boss is at a commanding position. So he is forcing the employee to enter into a illegal contract. Now, when is the person is deemed to be in the position to dominate the will of another, where a person holds a real or apparent authority over the other, like master and servant, money lender and borrower, police officer and accused, income tax officer and the assessee. In all these cases, we believe that the former party is in a commanding position, and it can influence the will of the other party. Yes, it's difficult to prove. So, where a person stands in a fiduciary relation to the other, that is a relationship of trust and confidence. Sometimes this also happens, like father and son, advocate and client, doctor and patient. Then the relationship of trust and confidence, it can be a blood relation or it can be a professional relation. You trust your doctor, but your doctor is cheating on you. So that is something illegal under the contract. So the case is of Moody versus Cox. So in this, X sold out certain property to one of his clients Y. Y filed a suit upon X claiming that the property was overvalued and that his consent was caused by undue influence. The court held that since the relationship of X and Y is of client, the existence of undue influence can be presumed. Okay, it was a fiduciary relationship. Fiduciary is the trust and confidence based. Professional, basically. So in this case, this client was the decision was in favor of the client. Okay. Then, in third case is where a party to a contract is a person of mental distress. When a person's mental capacity is temporarily or permanently affected due to advanced age or mental or bodily illness. If a person is not of sound mind, and if he is in that state only if he is signing any contract, if he is entering into any contract, then such a contract is void because he is not in a sound state of mind, and that also has to be proved medically. Now, what are the consequences of the same? The same as the coercion, same thing. Okay, its agreement is voidable, the refund can be taken, and if the other party cannot prove it or by choice they agree to it, then it's a valid contract. So what is the difference between the two? Threat of an offense. In this, there is domination of the will. This is of physical character, this is of moral character. In this, the intention to enter into contract, and in this, the intention is to take the unfair advantage. Now, in coercion, criminal act is involved, and in undue influence, no criminal act is involved. Alright? Did you understand the difference between the two? Coercion and undue influence, everybody? Okay. So misrepresentation, the third type of case where the consent is not free. So representation, we know what it is. Misrepresentation also we know. So it may be innocent or intentional. Sometimes it can be innocent and sometimes it is intentionally done. So now let us see what the definition says. It's unwarranted positive assertion. So X says to Y, who intends to purchase his land, that it produces 50 quintals of wheat per acre. X believes that the statement to be true, although he did not have sufficient grounds for the belief. Later on, it was found that the land produces only 30 quintals of wheat per acre. So this is misrepresentation. X is saying wrong things to Y. He is misrepresenting the facts. So that's the case of misrepresentation. So what are the essentials of it? There should be a representation of facts, not opinion. In this case, it was overvalued, Prabha, but not every time. Every time it can be any kind of misrepresentation. Okay? Even in marriage, sometimes misrepresentation is done, isn't it? The representation is, yes, very common. Representation is very untrue. Then the representation induces the other party to enter into a contract. If there is some kind of misrepresentation in a marriage, and there is a what we call it, if the marriage is legally registered, if it's a registered marriage, if you have obtained the marriage certificate, then it means your marriage is registered now. So in that case, you can easily prove that there was misrepresentation, and then the marriage may come to an end. So these are the essentials. And if there is misrepresentation, and the party who is claiming that there was misrepresentation should suffer from loss. If there is no loss, then we cannot say that the contract is void. So what are the consequences of misrepresentation? Again, the same consequences, and it can rescind also. Rescind is like you can you can accept it rather. Okay. Now the fourth category is fraud. So when any person makes to another a statement which he does not himself believes to be true, to induce the latter to enter into a contract, he commits a fraud. It is intentional misrepresentation. Okay, that one was that may be not intentional every time. Sometimes it may be innocently done, but fraud is always intentional. What are the elements of fraud? They must be making a false suggestion, like X says to Y that his coat is made of pure wool, though he knows that it is untrue. So Y purchases the coat believing X statements true. It is a fraud by X and the contract is voidable. This is the most common type of illegal element which we see in the contract, fraud and all. That's very common. It should relate to some material fact, something which is going to hamper your interest. That should be affected. Then to constitute the fraud, there must be an active concealment of fact. Before conclusion of contract, a promise made with any intention of performing it, and other parties must have realized and been deceived. So that is important. If these conditions are not fulfilled, then that won't be taken to be fraud. Now, when does silence amount to fraud? So, I just forgot to tell you about this one. In all the contracts, there is principle of caveat emptor. You know what is meaning of this one? This phrase, caveat emptor. Principle of caveat emptor. It says, this principle says that let the buyer be aware. Okay, let the buyer be aware means it is assumed that the buyer knows about the basics of the contract that has been entered into. So that is the principle of caveat emptor. Sometimes what does the seller do? He assumes this principle and then he conceals the material fact of the contract. So in that case, it's a case of fraud, because in this case the silence of the seller is leading to a loss to the buyer. Now, what are the exceptions? It is the duty of the person keeping silence to speak in fiduciary relations. Silence is in itself equivalent to speech. Fiduciary relationships, where there is some trust and confidence involved. So the person who has the responsibility should just share it. So A sells by auction to B a horse which A knows to be of unsound mind. A says nothing about the horse unsoundness. B says to A, if you do not deny, I shall assume that the horse is sound. A says nothing. So here A's silence is equivalent to speech. So what is B doing here? What is A doing here? So A is committing a fraud. He is concealing a material fact. The horse is of unsound mind. That is the important thing. Okay? This is half truth. Now the consequences of fraud are the same as the other one. Okay? The fifth type is mistake. In this case, the parties do not agree on the same thing in the same sense because of some misunderstanding. So it is known as mistake. Now there can be mistake of law, mistake of fact. It can be bilateral or unilateral. Bilateral, both the parties are like making a mistake. Unilateral, when it is from one side. So in bilateral it is mutual and it's a matter of fact. It can be other things. The subject matter can be existence, identity, quality, quantity, price, a possibility of performance. So, like when a mistake is done, sometimes this happens. Not every time. Not very common time. So unilateral mistake is no mistake unless mistake is brought by misrepresentation or fraud by the other party. So that is why it comes in all types of insurance contract. It basically comes in all types of contracts. Okay, it can be a business contract, it can be insurance contract, any type of contract. It can be a house rent agreement. That is also a contract. So basically it applies to contracts. Now, exception to this is the identity of the person contracted with and nature of the contract. Means sometimes if no harm is done to the other party, then we may assume that the nature of the contract is of that type and no harm has resulted, so we can just overlook it. That is one exception to that. Okay, so this was free consent. Now the next important topic is the legality of object. Legality of object means every contract that is entered into should be legal as far as its object is concerned, and there should be legal consideration also. Okay. Now, what does this mean? Legality of object. Can you give me one example? Can you give me one example? I'll give you one example. Smuggling. That is an example of illegal type of contract. Although both the parties are gaining from it, but still the contract is illegal because it is forbidden by the law. So if an agreement is to be enforced in a court of law, both consideration and object of the agreement must be lawful. Like if somebody is entering into a contract and the consideration for the contract is cocaine. You understand what is cocaine? What about others? Asya, Ashwin, Sahel, Rajiv, Akshita, Sanubal, Habibur, Nazar, Muhammad Tariq. Cocaine is something that is illegal. So if the other party is giving to the, if like X is giving to Y cocaine in consideration for the contract, then that is illegal. In order to constitute a valid contract, both consideration as well as the object must be lawful. Otherwise, it would be void. Now, when is the consideration or object unlawful? If it is forbidden by law. Like law forbids an act for various reasons. If the consideration or the object of an agreement is doing of such an act which is forbidden by law, the agreement is void. As I told you, smuggling. That is something that is forbidden by law. If a person is, but still there are people who are doing it. So that is something that is forbidden. Then, if it is of such a nature that if permitted, it would defeat the provisions of law. It refers to cases where there being no express statutory prohibition against a particular type of contract, the nature of the contract is such that it would be against the spirit of particular law, whether enacted or otherwise. Homemade weapons trading. Yes, it is forbidden by law, but still people are carrying on that trade. And there is a contract because they are like exchanging it for a consideration. One party is supplying the weapons and the other party is paying for that. So it is a contract but not a valid contract. If it is fraudulent, so it refers to a contract which are entered into between the parties with an object which is fraudulent or with a purpose which will in effect promote fraud. More or less the same thing. Okay? If either it is fraudulent or it is promoting kind of fraud, that is not acceptable. If it involves or implies injury to the person or property of another. If the object of an agreement is to cause injury to the persons or property of another, it is unlawful. So injury means criminal or wrongful harm. So any agreement to commit an assault is void. It is not acceptable. So if the court regards it as immoral. So agreements which are contrary to good morals are illegal and void. So if the consideration for the agreement is an act of sexual immorality, the agreement is illegal. Any kind of immorality, whether physical or mental or sexual, any type. If something like this is involved in the contract, then the contract is believed to be illegal and void. Yeah, where the court regards it as against the public policy. Did you see that news of that incident which took place on last Friday, Uber cab in Delhi? A girl was going home from the office in Delhi. She was raped by the cab driver, Uber cab. So that is something which is against the public policy. So that type of act will be included in this type. Now, what are the agreements opposed to the public policy? The first is trading with enemy. Yeah, agreements with alien enemies would injure a states in relations with other states. So it is unlawful to enter into a contract with a foreign enemy during war or to perform such a contract entered into before the war. Like you are having, I am giving one example, like India is not having very peaceful relations with Pakistan these days. There's a lot of tension between the two nations at the border. So trading with Pakistan at this point of time is believed to be something opposed to the public policy. Now, if suppose there already a contract has been initiated, means it was signed before the situation which is prevailing today, it was like maybe done 6 months back, then the situation was peaceful. But now the situation has turned very hostile, and in such a case, carrying on trade with Pakistan will not be regarded as a something that is that is in favor of the public policy. It is against that, so it will be avoided. Trading with enemy. Now, agreement for sale of public offices and titles, where the object of an agreement is to sell or transfer a public office from one person to another, or to secure honor or title of monetary consideration. The agreement is void. Now, have you seen that movie Bubbly and Bunty? Bunty and Bubbly. Have you seen that movie? Yeah. So in that movie, what they were doing is they were selling the Taj Mahal. So what was that? That was a fraud. That was an illegal act. So things like that are illegal. Now, agreements by way of maintenance and champerty. So maintenance means an agreement in which a person promises to render help by money or otherwise to another person in a case in which the said third party has himself no interest for its prosecution or defense. Means the other party is not having any interest in it, but still they are helping in the like we can say running of the case. So this champerty, what is this? It is an agreement whereby one party is to assist another in recovering the property and so share the proceeds of the action. Like there are some agencies especially meant for this purpose. So those are champerty contracts. Now this all is caretaker. Okay, yeah, property caretaker we can say. Just read this, all of you. They are very easy things. So just read it and then we'll go forward. Everybody, please read it. Once you are done, let me know. Did you read it? All right, Praveen. No problem. It's okay, Rajiv. You read that? Others are reading it. Okay. So there are some more agreements and restraint of marriage. Like freedom of choice in marriage has been guaranteed to every person who is major. Major is more than 18 years. So if the object of an agreement is to restrain a person from marriage, such agreement is void. Then agreements to defraud creditors or the revenue authorities is not enforceable. Like if you are entering into some kind of contract to cheat the income tax department, that is this type of a contract. So it's illegal and not valid. Agreements in restraint of trade, where the object of an agreement is to interfere with the freedom of a person to carry on any lawful trade or profession. The said agreement is called agreement in restraint of trade. Like, you know, what happens, sometimes this happens in, I have seen this in the film industry. Okay, Prabha, I'll get to that one. I'm just telling about this 12th one. In the film industry, this happens a lot. You know, if a particular banner is launching a new heroine, then or a hero, what they do, they ask them to enter into a contract that for the like they will be first of all doing 3 films with them only, and then only they are going to work with any other banner or any other company. So this is agreement and restraint of trade. You are restricting the freedom of a person to carry on his or her profession, isn't it? Do you agree to this? No, Prabha, we don't think so. This is, you are not letting them work on their own. You are binding them in a contract that first you have to do 3 films with us, only then you can go and work with any other banner. So this is not like fair, I can say. Yeah, that's it. Okay, now what are the exceptions to this? They still have the choice to refrain. Still they are in the contract, like this actress, Pariniti Chopra. She was into the contract with Yash Raj Films, that she will be first doing 3 films with them and then only she can work with any other banner. So this was so. So suppose their 3 films take 5 years in making, then what will happen? In 5 years, there's 3 films the person is doing. That's not fair. Now there are some exceptions to this rule. Like first is the sale of goodwill. So one who sells the goodwill of a business, it may agree with the buyer to refrain from carrying on similar business, so long as the buyer carries on a like business thereon. Like this, this is very much there in the business industry. Like if there is a firm which deals in paints and stuff like that, and it is a 75-year-old firm. Then what do? They sell their goodwill. They lend their name to another party, and that party carries out the business in their own name, like in their name only. They put the same name, and they are working as a franchisee, we can say. So that is sale of goodwill, and that is not an illegal thing because a contract has been entered to sell the goodwill. Then under Partnership Act, a partner shall not carry on any business other than that of the firm which he is a partner. Then an outgoing partner may agree with his partners not to carry on a business similar to that of the firm within a specified period or within specified local limits. Okay, like he may just enter into a contract like this. So that is not refraining from the trade. That is by choice. And even this one, the example which I gave you, the 3 movie example, that is also by choice only. Then this says partners may enter into an agreement among themselves that none of them on ceasing to be partner will carry on any business similar to that of the firm within specified period or within the specified boundary. Like if he is leaving the firm, so he agrees that he will not carry out a similar type of business. Now, but these are some other exceptions. The first is trade combination. Traders and manufacturers in the same line of business normally form associations to regulate the business or to fix prices. Can you just read this? Okay, so now just little time left, so I'll just wind it up. Like trade combinations. So trade combinations is like it's a I can say it's a panel or a platform where the traders and manufacturers who are in the same line of business, they form an association, and the purpose of the association is to regulate the business and to fix the prices. So the regulations as to the opening and closing of the business in the market, licensing of traders, supervision, control of dealers, and mode of dealing are not unlawful even if they are in restraint of trade. Like if there is a particular market and a time has been allotted for the opening and the closing of the shops, a particular day has been decided on which the shops will remain closed, that market will remain closed. So that is not an illegal contract. That is exceptions to this judiciary. It's a trade combination, and if you are a member of that association, you have to follow the rules and regulations. Okay? Then sole or exclusive dealing agreement. In business, appointment of sole selling or distributing agents is quite common. So such agreements have been held to be perfectly legal. Like in a particular state, there will be just one wholesaler or distributor who is going to sell that product. Suppose it's a footwear. So that is, I am the manufacturer and I am not going to appoint any other party as my dealer. So that is again valid. It's by choice. Yes, we can say it's a monopoly. Then service agreements. Restriction during the service shall not be void, but after the termination of service, an agreement by which a person is restrained from competing with the earner master shall be void. Means if he is doing the same thing, same type of a business, that's illegal. Then uncertain is when the terms of contract are uncertain. It's not fixed. That is again a case of illegal contract, void contract. Okay? Did you understand these points? What about others? Chita, what about you all? Some of you went offline in between. Rahul, you were also one of them, isn't it? All right. So this is just one part, and there is one important topic, that is consideration, which we couldn't do today. So we'll be doing it in the next class. All right, everybody. So we'll be meeting in the next class. Next class on Saturday. Your class is on Sunday, I guess. So Sunday at 8 o'clock. And if it is on Saturday, it is 7 o'clock. Alright. So make sure you are attending all the classes, because these topics are all in like continuation. They are interrelated. So make sure you are there for every class so that you don't miss out on anything important. And thanks for your time, everybody. Thanks for attending the class. I'm glad to see a good number of students in the class. Thanks for your time, everybody. So hope to meet you all soon in the next class. Bye. Take care. Good night. And please fill the feedback form, which you will be getting at the end. Okay? Just give your feedback, which is there in the feedback form. It's like a motivating force for the teachers. They are able to assess themselves. Alright? Thanks for your time. Bye.